who are not able to make it here tonight. And so good evening, kia ora koutou everyone, and welcome to the Senior Mooting Seminar. So again, let me just reiterate, can we please keep our mics and videos off just during the seminar? And if you have any questions, please just send them through to either me or through the general chat or to our development officer, Maria, who is also on the call tonight. This evening, we are joined by our wonderful speakers, Diana, Don, and Josie. They are not just some of the best mooters at Auckland Law School, but I would actually say that they're some of the best mooters in the world. So we're very lucky to have them here sharing their expertise with us tonight. I will leave their self-introductions to themselves, but before we get to that, I'll just quickly run through how this seminar is going to work. So overall, this is going to be kind of like a structured Q&A session with me throwing questions at our presenters to guide our discussions and to solicit advice for mooting from them. And I have largely broken the evening down into, I think, 4 parts. And we will begin with questions about reading and analysing a moot problem and finish with questions about oral submissions. If you have any questions, please do send them through, and I will try and get through to all of them or just try and keep the discussion going. So with that being said, I will now hand this over to Don, I believe, to start us off with a self-introduction.
Hi everyone, my name's Don, and thank you, Aria, for that lovely introduction. And honestly, would not agree with the best mooters in Auckland, let alone in the world, I think. Maybe Diana, but certainly not for me. So my name's Don. I'm currently a Judge's Clerk in the Supreme Court. I finished most of my papers in 2020, and I'm currently at the second year of my Judge's Clerkship. I grew up in Singapore, and then I moved here when I was 16, before I did 2 years in the Army, and then 4 years in University of Auckland. So that's just a brief introduction from me, and it's on to you, Diana.
Kia ora koutou katoa. My name is Diana, and I, like Don, am also in my second year of a Judge's Clerkship. I'm not at the Supreme Court, I'm at the Court of Appeal, and I'm also a teaching fellow at the Victoria University Law School. I also disagree with what Aria said. It was a very kind introduction, but for those of you who aren't briefed on our association with each other, the presenters, Don, Josie and I were part of the 2020 New Zealand JESIP team, the JESIP being the world's most prestigious international moot focused on public international law. We competed as part of that competition in the European regional rounds, otherwise known as the JESIP European Friendly, and we finished as second runners-up and took out the prizes for best, second best, and seventh best speakers respectively. So that is perhaps Aria's interpretation that informed her introduction. And I guess that's all I'll say about me for now.
Kia ora, tēnā koutou katoa, ko Josie tōku ingoa no Otaranga hau, anō hoki no Pākehā hau, kei Pōneke o te whanganui ātara taku kāinga. He mihairo hoki tō kaupapa o taku kaupapa. My name is Josie, I'm from Otaranga, but I live in Wellington at the moment. And I am very pleased to be here. It's a really cool kaupapa to be a part of. I'm always in awe of my colleagues, Diana and Don, who are very great mooters, so it's also cool to be here with them. I work at Te Kōti Mananui or Aotearoa, so I'm a Judge's Clerk at the Supreme Court, as well as Don, which is great. And yeah, happy to be here.
Awesome. Thank you guys so much for that. And I stand by my statement, guys, but I digress. Going into the discussion, the proper discussion part of this moot, we will start by going through some questions about when you first approach the mooting problem. So I guess to kick this off, my first question, just to get the conversation going, is what are your tips for when you're reading and analysing a moot problem for the first time?
I think I can kick this discussion off, and I'll start with a disclaimer because I think perhaps the three of us each have different preferences or different styles of how to read and approach the moot problem for the first time. But what I tended to do when I was a student was read over the problem a first couple of times before diving into the authorities. And I read the problem, I think, 2 or 3 times right in the beginning. The first time was a read through just to get the general sense of what's happened, and then get to the issues that are posed to you right at the end of the problem. And that first read through is really just without prejudice, without any bias or sort of impressions read through, to make sure that you have the opportunity to absorb everything before you start getting into the authorities. My second read through was more filtered. My second read through, I worked out what the issues were and the questions that were asked of me. And so I read back through the problem with those issues in mind, and underlined the facts that I thought may have been at first impression relevant to those particular issues. And then I did, I think, a third read through to just make sure I wasn't missing any details. So that was what I did in terms of reading the problem. In doing that, I also annotated various parts of the problem. So things like particular moments, like when things started to go wrong, for example, which I called watershed moments, and also what pertinent arguments were presented in the court below, and therefore which arguments persuaded the judge to find a particular way were also things that I highlighted. So that's, I think, what I'll say about reading the question for now.
Yeah, is there anything you'd like to add to that, Don and Josie?
I'd only add I'd probably a far less structured approach to Diana, but maybe that's just my approach to life, a little bit less structured than Diana in general. But I mean, I totally agree everything that she said. I think, though, the other thing I'd probably bring up is it's totally normal to read a question 2 times even and still be like, what the heck is going on? And sometimes it is good to know the facts and to read the question, and then when you engage the authorities, that might be when the things start falling into place in your mind. So I wouldn't freak out if you read a question and really are like, oh my gosh, I have no idea. The other thing I'd like to add is just once you have read the authorities a bit, I would go back and read your facts again and decide, count what are your red herrings, or what are certain facts that people might think are really important, but they're actually not that important, because I think that there's always going to be a few facts that people will heavily rely on, which aren't necessarily, they might be there to trip you up, or they might be a red herring, so it's always good to be critical when you're reading your facts. I think is really important, but that might also come once you've kind of become a bit more familiar with the question.
Yeah, Don, anything to add to that?
Well, I think most of the things have been covered by Josie and Diana quite thoroughly. I would just sort of echo what they said, I think, it's sort of, the entire process which you sort of take towards a moot problem shouldn't be that different from a problem question in an exam, to be honest. Like, you just want to read and reread, the question and make sure that you have all the facts in mind. Yeah, so I think sort of leading into the subsequent parts, I suppose, you definitely want to have all the facts fully memorized before you go into the the moot, I suppose. And I just have a quick, I just suddenly remembered, I think during just a moot, I think, so Diana had printed out the facts, and then she had highlighted and annotated it, and she kept that one piece of paper throughout the entire time, and it became the most rattiest and disheveled piece of paper. But that was just goes to show how much she actually went around reading it. So I think that's really what you have to do. And I think the second thing in terms of the facts as well, so I'm focusing specifically on the facts, is that basically cases are won on the facts. So basically you always want to come to the facts and link whatever law there is to the facts of the particular case. And that will allow you to distinguish a lot of the authority from before and make your argument. So that's just the way to sort of approach it. But that's pretty much all for me.
Yeah, I love the ratty fact question thing because I've done that for so many moots as well. I think for moot problems, the fact definitely isn't a read once and be done with it kind of situation. And I'm just thinking about a lot of audience, I think, who are here tonight might be thinking about approaching or participating in the John Hay moot and Stout Shield. So keeping that in mind, are there any specific advice you give them in preparing for, like, say, a criminal law kind of problem or like a more tortious kind of problem?
I think the other thing, and maybe this is something that we're going to get on to further, so I don't know if I'm like going ahead a bit, but is that you're always going to have bad facts. I mean, and this is true of like whether or not it's criminal law, but especially in maybe criminal law kind of problems as well. Like you're always going to have facts that don't favour you or do favour you. Don't freak out about those. That's how it's supposed to be in a moot, right? Like and that is like the reality of a case. You don't choose what case you get given. You just take a case that's before you. So it's all about like acknowledging the facts that don't support your case and like having a strategy with how to deal with those, and maybe being aware of that from quite an early stage.
Yeah,
I've done.
I've got to say, I'm a little bit. It's been almost 5 years, I think, since I did John Hay. And I've got to say, when I was doing mooting as a student, I don't think I approached a criminal law problem in any particularly different way compared to the civil or commercial law problems that the Greg Everard and the Stout Shield raised. But I think in hindsight, I'd probably say you've got to be conscious about whose burden it is to prove what. And I think in the criminal law context, that question may be more important on appeal, or rather you just got to be more conscious of that on appeal. So I'd say always be clear in your argument who has the burden of proving what, and make sure that that's something at the very least you've got a question, you've got an answer to, in case the judges ask you who has the burden of proving X thing in the moot.
Yeah, Don, did you have anything to add to those points?
Something very short, I think. So for criminal law, obviously, like we have the Crimes Act, which is the legislative code which we go off with. So you know, if you had a criminal case, that's the first sort of port of call you would have, and then you basically be sort of looking to fill the gaps with your case law and your textbook. So I think in terms of how you approach a case in criminal law, there's no specific way, and it really depends. So for example, like Diana said, there's no particular way that's prescriptive for all situations. So for example, when I did John Hay the first time, I think it was based off insanity, and so that's very, very case law heavy. So in which case, like you would just be looking very heavily at the textbooks and the cases because there wouldn't be much in terms of legislation.
Yeah, great points. And actually, it reminds me when Diana was saying, you know, be conscious about whose burden it is to prove what. I remember a solicitor at MC telling me there are some hot like keywords like defense would always try and employ in criminal cases. For example, like if it's evidentiary, then they're always like the prosecution needs to offer concrete and tangible evidence, or just phrases like that, which I'm sure come through in research and case law that people can employ in their own moots. So I think that's a good place to leave the first part of like reading a question. Let's move on to questions about forming an argument and, you know, actually beginning the research. So now we've read the problem, and I guess for a lot of younger mooters who are less experienced, the first question they have is, how do I structure my argument? Do you guys have any pointers to give on that point?
I can jump in on this quite quick thing. So, so this was something that Tian Nelson told me when I mooted for Stout Shield, I think. But what he said was that you want to think of your structure in terms of what are the hurdles that I need to prove in order to reach my point. So for example, I need to cross hurdle 1, hurdle 2, and hurdle 3. If I fail either of these hurdles, then my case falls through. So that's a very good way you can structure your argument, because you can tell the judge, I have 3 propositions, and then you hone each of these propositions with precision, you support them with authority, and then you can like summarize them and keep and sort of like push them through. So that's the point of it, I suppose. You need to think about, how do I win this case? What do I need to prove it? Is it an argument, an alternative? Like, can I fall on this point and rely on another point? And then you just want to bear this at the front of your mind, I think, when you structure your argument. And it's just really very clear and very effective, I think.
Yep, so it's like a very realistic, I think, and practical approach. And I think sometimes law students tend to approach things in a very like legal essay sort of way, instead of cutting straight to the point. Josie and Diana, do you have any advice you'd give on people trying to form the first time?
I would just really make it so that you know what's in your mind. What are the points that you can concede and what are the points that you can't? So it's similar to what Don said in that, yeah, like how do you win your argument? But also like, don't get caught up in the weeds. Like, what do you need to prove? Or, do you have 3 alternatives? Like, I can get home on this avenue. I could also get home on that avenue, or I could get home on this one. And like, or do I need to just do option A? And I think what's good is to work out, what are the hills that you don't want to die on and you don't want to spend a long time on, and what are the things that are really important that you need in order to push your case forward. Because there might be minor interesting points that really you could concede if you needed to. And I think like making a reasonable concession is always quite, I think, impressive to judges, knowing when, you're not going to die on that hill, I think is important.
Yeah, I absolutely support everything that Don and Josie have said. I think what I'd add to that is sort of, I guess, trying to get you guys to imagine how your argument would look like on paper. And so from the moot problem that you have an issue, so that and one of the issues is usually formed like in the form of a question. So like, did the judge err when he or she found that it was that Mr. Smith defamed Mr. Williamson or something? Underneath sort of that question, or like the main heading you have, say that you're on the side of supporting that Mr. Smith did defame Mr. Williamson, then each of your subheadings the sort of templates that are available on the Mooting Resources Drive, each of those should be what Don termed your hurdles. I like to use the term milestones, and those are the things that you need to prove and lock like gates before you can move to the next milestone, and then finally move to your conclusion. Those milestones need to be relevant to the ultimate outcome that you desire, and they also need to logically flow from one another. The upside to this as well is that if you should choose your milestones based on, if the judge found against me on this, it will be difficult for me to proceed. So what I mean by that is, sometimes what I've seen in written submissions is people including subsections, milestones that don't really have much of a bearing on the case. Like, for example, they could have a milestone that's like, oh, this interpretation of the provision is consistent with policy, which like by itself, I don't think is ever really going to win a moot. Rather, that factor is just something to weigh in the round. So what I'll say there is, your milestones or your hurdles need to be relevant, logical, and they also need to be the most important points. The second thing I'll say here is, it's normal not to immediately know what your structure is going to be. And oftentimes I would read the authorities and adopt the structure of the argument and the analysis that came forth from the reasoning from this summary of party submissions in the judgment. So that is why reading the authorities fully is really important. So you get a sense of how an argument in your case could develop.
Awesome, thank you. That is very specific advice, and I'm very sad to report I have made the mistake of including not super important milestones in my structure very recently. So yes, that's very sage advice for me to take on board as well, actually. And speaking of authorities, I think a really good topic to discuss is what do we do when the weight of authorities is against our position? And maybe just in the same vein, how do we, approach facts that don't really, swing our way? Like, what strategies do you employ? What sort of case theories do you, come up with to deal with these tricky situations?
Well, I think the first thing I would say is that that's going to be taken into consideration by like the judges anyway, like in a moot, if the case is against you, essentially. The second, I think, is that you just have to do with what you have, really, and so that means sort of vigorously defending your case, but also not pushing it to the point of absurdity, I think, and trying to force like ridiculous positions. And so I guess this comes back to what can I do to support this case if all the case law is sort of against me? Well, that generally will happen quite rarely, I think. You generally will find at least a few cases that will support you, even if it's not entirely on point. And what you can do as well is that if there could be all these cases saying something, but then you could, look very carefully at those cases, and very often you can find a certain principle that those cases are based on. You can say that potentially this principle doesn't apply to this specific scenario because of XYZ, and so you could either distinguish those cases or be like, those cases were meant to deal with a particular situation which we don't have right now, or something like that. And other things as well, I suppose, is that you can support your argument from first principles. So this is not sort of arguing entirely based off policy, but what this means is that you support whatever you have by just like fundamentals. And so I do remember one situation, I think, where this must have been in the Stout Shield about 2 years ago, I think, and this was where I think Sophie and Jane had won the Stout Shield. And so I remember quite clearly that that case was about consideration, and Sophie had been pushed into a corner essentially and having to argue that get rid of consideration entirely from the doctrine of contract, which is a pretty like extreme situation. But what she had done was that she really substantiated it based off first principles. I think she was just saying, if there's like objective agreement, then why do we need consideration? So but the point is that she clearly worked, and I'm not saying that you should rely on first principles and just all the time, but you should certainly use first principles together with precedent, together with your policy, and then you can cobble together whatever best you can to defend your client's case. The last, you can also, depending on who the onus is to prove the argument, I think you can focus poking holes in your opponent's case. That needs to be taken with a grain of salt, I think, because you ultimately are, your case is about proving your case, not your opponent's. But very often you can sort of try to shore up if your case is just weaker legally by focusing on the weaknesses of your opponent's case, especially it's the onus is on them to prove it.
Yeah, cool. Thank you. That's a lot of substantial advice, actually. Josie and Diana, do you have anything to add to that?
I will say that Don's right. Your goal as a mooter, even if you are on a side or an issue in which you think that the weight of authority is against you, is to always try and be the most reasonable person in the room. And so what that means is, even if you are on the side where the weight of authority seems to be against you, chances are there is going to be something out there that is still able to, that you're able to use to then support your argument, whether that's in a dissenting judgment. In a few of the other cases, there are reasons why the judges in those cases will have adopted the position that they did, even if it is a minority of opinions for why they adopted that position, and then apply that to the of your case while still being as reasonable as you can. The other thing that you can do, and this is also very similar to approaching a problem in an exam, is it, to the extent that you can, but again, distinguish on a reasonable basis. So if something is, you want to be looking at the material facts of a case rather than just all of the facts. And if there's a material fact that you can distinguish that is important to the reasoning of the judgment, that means that judgment may not fully apply to your situation, then that is also a method that you can use to persuade the court why they shouldn't find that case as persuasive as they otherwise would. So that is another tool you could have in your
I agree. I think being able to distinguish cases on the spot shows the judge, which is always good to see. And Josie, opinion on this matter, would like you to expand a bit more on, what first principles are and how to employ them in the arguments, because they're not quite, like law.
Well, that's quite a difficult one to answer in the abstract, I think. But just to take what Sophie had said in terms of the consideration and first principles point. So what she had done was that, all right, so we have all these cases which say that we need, consideration, and this has been, in the common law for as long as we can remember. But if we think about what a contract is about, it's ultimately about an agreement, between two people. And so if they agree and they have that, intent to create legal relations, then why do we need something like consideration? Because and then what she had done, I think, was that she had looked at there's this case which essentially said that if there was a variation of contract, like you don't need the same level of consideration or something. And she was like, oh, you look at, now the courts are like twisting themselves all over trying to create these different sort of like precedents. And so, to keep everything consistent and coherent, it's better to just do away with consideration entirely and stick to the first principle idea of, is there an objective agreement? So that's one way you could sort of, frame that argument in terms of first principles. Well, I think you're right to say that first principles isn't exactly law, but ultimately we have all these legal positions or cases which are founded upon those principles. So, and that's essentially what the judges use to decide the cases. So it is still law in that sense, even if it doesn't produce like a strict outcome in this specific situation. And we're getting quite into like jurisprudence area, so I'm just going to leave it at there.
Yeah,
I feel like I agree with Don in that, but I'd also like to expand in that, like, sometimes when you talk about first principles as well, it might actually also mean, or like the way that I kind of understand is like, what's the purpose of the law in this area, or what's the rule, or what's the overarching rule? Because you might have a specific case that has said something very particular about how a rule should operate or its application. But sometimes if that's not in your favour, you can look at, okay, what was the purpose of this section, or what was the purpose of this rule? I think that's also like a good way to kind of try and like put forward your argument to get around maybe something more specific that is kind of not in your favour. Yeah, but other than that, I think Don and Diana have talked about everything really well, so I don't have anything further to add.
I agree. And that's, oh, sorry, Diana.
No, I just wanted to really echo what Josie said about thinking about the reasoning behind why a law exists. So because we all know, like, the law is made up, but it's made up for very good reasons. And it's a matter of figuring out through the case law, through the interests and the stakes that judges in the past have had to consider, and how they've used the law to meet those interests and stakes. So I'm like, for example, I'm dealing with a nuisance case in the court at the moment, where the parties in their submissions have given us a sort of summary of the history of the development of the tort of nuisance. And it's clear to me in reading through that summary that at various points, the courts have given various fact situations that the pre-existing laws cannot strictly apply. The justice of the case, and the justice of the case should favour the plaintiff or the defendant, they make up incremental developments to that law to fulfill what is their sense of justice. And that's because there are interests to be met, and ultimately the law should be, to the extent that it can, meet those interests while balancing the interests of others. So I highly encourage people to think about the way the law can do that in their particular fact situation, even if the weight of existing authority is against them.
Absolutely.
One
And
final thing very quickly, I think.
No,
Oh,
go
sorry,
for it,
Aria.
go for it.
I was just, so in terms of case law as well, like people just think that cases say one thing, but that's not really the case. You can really read cases in like a million different ways.
Oh,
And so it's very easy
totally.
to, it's not probably the most ethical, just need to be gracious enough to find that and really persuade the judge, like, no, this is actually what it meant, even if in your heart you think it's not, but you can usually do that somehow.
But please be reasonable about it.
Yeah, for sure.
Yeah, I mean, and that's true. I mean, even statutes, there's arguments is actually the correct interpretation of the statute supports, this particular application of the law. And on a practical kind of point, why it's, I guess, all this policy and this reasoning behind the law is important is because you're never going to get a moot that's an open and shut case. Like, moot problems are specifically chosen in areas of law where there is a lot of contention or there is a lot of debate. So, for example, it'll either be an emerging area of law or it'll be something that has, raised questions in the legal community. And because the moot problems are continuously updated, these will be pretty up to date debates about really where New Zealand law should go on some contentious points. So I think that should be a good point to leave the forming an argument point, and let's get into part 3 about actually writing the written submissions. So first of all, let's start with talking about what common mistakes you find in reviewing written submissions. And I'm sure you've seen many written submissions both as a mooter but as a law clerk. So I'm actually very curious to hear.
I think me and Don have seen some pretty cooked submissions before, but
yeah, some of these submissions you would wonder if they were written by first years or something, honestly.
Wow.
It's kind of a surprise.
You're all like a philosopher. I don't know.
I've seen a reference to the Hunger Games once, I think.
Oh.
Yeah.
Yeah, it did not make sense.
Yeah. I think written subs, I mean, the way that I always wrote, and this is just how I live my life, is I just absolutely mind dump and then go back and be really, really critical. Because I think, and I'm not saying this is how you're going to write off the bat, because this might be like a series of iterations, but you just need to make sure that by the end of it, your written subs are extremely clear, follow a really good structure, and stick to the relevant issues and provide enough facts, but you're not going on a tangent. And I guess I actually think people go on a tangent more about the law sometimes than they would about the facts and leave the facts out. So I think the legal analysis you do, it's so good to know all of it, but you might not put everything that you've researched and studied into your written submissions, and sometimes going on a huge legal tangent in your written subs I don't think is particularly helpful.
So is it essentially kind of striking the right balance between showing that you know the area of law, but also applying it to the relevant facts at hand?
Yeah, totally. Just like a written problem at law school. And keeping it super tight to the issues is really important, I think. What is your case about? What point are you trying to make? In your as your overall case, just keeping it relevant. But yeah, I feel like Don and Diana will definitely have some views on that.
Well, I think just to make a quick few points. I think in mooting and in practice, I think the function of written submissions will be very different. I think in your moots, you guys said is that you really have to keep it as bare bones as possible, you're not really going to be able to fully flesh out some of your arguments. So what I found the most helpful as a judge and as a mooter, I think, was to leave my submissions in a frame as a framework, or sort of a roadmap for what my oral submissions are going to be. So like basically a judge can sort of refer to my written submissions and like sort of follow that, and use my oral argument to sort of fill in those points. I think Diana and Josie probably will have potentially different views on that. The only thing I can say is that you generally have a lot less that you can put in your written submission. So you just want to stick to the key propositions, put some authorities there, and then rely.
Yeah, I agree with Don. I think it's also hard, like Don makes the good point. I'm thinking about in practice sometimes, where in practice you'll have written subs and then what you actually is before your hearing. So it is kind of mass of our collective existence.
20,000 words, I think.
But I think for a lot of moots, you don't have the ability. Pardon?
20,000 words, yeah. I think that those are our written submission length, or like that was ridiculous, yeah.
I'll jump into talk
but
about
I know
one
for
of,
a lot of moots, you
sorry.
don't have that. No,
sorry, Josie.
Go, Diane.
I'll jump in to talk about one of my pet peeves with written submissions, and it's that it's not having effective topic sentences. So oftentimes what you'll find yourself doing in written submissions is that beneath each of your milestone headings, you have a series of paragraphs which is meant to develop your milestone heading. My problem is that oftentimes law students fall into, mooters fall into the trap of following the IRAC structure far too strictly, in the sense that at the very beginning of one paragraph, they state what the law is, and then they go on to explain that maybe with some footnotes. And then at the very end, they conclude with a statement about why that's important. I actually think that with written submissions, the structure for that should kind of be reversed, in the sense that your topic sentence should immediately get you to the point that is going to be material to your argument. So instead of saying, in this case, Justice William Young stated this proposition, you could say, you could immediately start that paragraph with the factual conclusion you want the court to find. So you could say, Mr. Smith, the statement was about Mr. Smith. This is because, et cetera, et cetera, et cetera. This is supported by Justice William Young's statement in whatever case. And that way you prioritize the factual and legal conclusions you want the court to make over, and then you use the law to support that, rather than the reverse. And I think that's often a mistake that I've always seen in written submissions, not just student ones, but also international ones. So it's a very common one, and it would be great if that could be less of a thing. So I'll say that. The other thing I'll say is also to make use of sub-paragraphs or subsections. So sometimes the law might be contentious. Sometimes you might literally just need a paragraph that states what the law is in the abstract, in which case you could use subsections or sub-paragraphs to further develop those details. It's all a matter of being strategic and thinking to yourself all the time, how am I going to be the most persuasive I can to this court? And the final thing I'll say is similar, going back to what Josie mentioned earlier about how in the early stages it is very much like a mind, effective and good, take time to refine and to perfect. So oftentimes it may just be a mind dump right at the very beginning, but then towards the end you sort of step back and you're more familiar with the case and you're more familiar with the authorities, and you realize, oh, okay, these are the fundamental points I want to make. And then you go back to your written submissions and think to yourself, how can I redraft these things to make these fundamental points I want to make? So it's a process that takes refining, and we know it because it took us 3 months to write our dissertation with the submissions.
I definitely feel the pain of massive submissions, because the ICC subs are about 10,000 words for each side. So that definitely ruled my life a bit. Tracy, I'm not sure if your audio is working quite well. I don't know if it's my laptop, but I don't think what you're saying is coming through. Yeah.
Yeah, it's a bit buzzy.
Is that better or worse?
No,
Oh,
it's great now, yeah.
Yeah, way better. Way better.
Oh, sorry guys. I was just going to say as well, with some of those bigger subs, and this might just be more relevant to like GESIP and ICC type stuff, but we were always told to like really beef up our footnotes. I don't know how relevant that is when you have when you only have a few pages, it might not be that relevant, but I think when you don't have a lot of like space to show that you have really traversed the case law, or that if you do want to rely on quite a few cases, but you don't have time and the space in your subs to discuss them substantively, chucking them in a footnote, and then at least they're there so that the court knows you might refer to them, or they're kind of in the realm of what you're going to talk about. Yeah, I don't know what Diana and Don think about that, but yeah.
Yeah, what do you guys think about that? Because I've definitely done for internal moots, I've definitely done like say a paragraph and full of like short statements and like a different footnote behind each statement. I don't know what you guys think about that.
Footnotes are great. They're a good opportunity to clean the main text and strip it so that the main text only provides your most important and relevant points. If it's not necessary to mention the name of a case, chuck it in a footnote. If it is necessary, like for example, the law is contentious on an issue, or if it's a leading case, might be worth putting in the main text. But yeah, use the footnotes to aid the main text and to cleanse it of all the irrelevant or less relevant and extraneous material.
It's basically Diana's skincare routine.
Yeah, no comment.
I did actually want to say something earlier when Diana was talking about using like topic sentence and making it like just really clear what you're actually submitting to the court. And look, this sounds kind of ridiculous. Just during my Stout Shield finals, when the judges were giving submissions, one of the judges told me that one guiding principle I should always keep in the back of my mind when doing legal advocacy at like in a courtroom is tell me what you want, what you really, really want. And that's what judges want to see from mooters. And I think that's kind of echoes the sentiment that we've shared here today as well. I do have another question for you guys on the written subs. Do you ever address obvious counter arguments in your written submissions, or do you anticipate the opposing counsel's arguments in the written subs?
Yes. So I'll immediately step in here to say a few things. The first is, if there is an obvious counter argument, it's not only your duty probably as an officer of the court to address that, but also I think it's also going to make you look more persuasive if you do find a way to address that in a smart way. And here, my tip is to sandwich the counter argument in your written submission somewhere. So in a way that doesn't give a lot of airtime to that counter argument, because ultimately it's for your opposing counsel to raise and to erect. So a way of doing that is to begin the counter argument with qualifying words like while or although. So for example, you could say what your position is. So you have a really good effective topic sentence. Mr. Smith, the statement was about Mr. Smith. And then you could address the counter argument in the next sentence. While the statement includes features that people would often associate with Mr. Smith, and then you would conclude that statement, however, in a way that you want the judge to deal with that counter argument. So my advice there is to what I call sandwich counter arguments within your main submissions, because ultimately it's not for you to bring up those counter arguments, it's for your learned friend, but you still have to find a smart way to address them somehow.
I remember actually on that point, last year's nationals, when I was talking about the problem question with you, Diana, it was about defamation and like the threshold of harm that we should adopt to action defamation cases at the court. And essentially, I think the two competing arguments was there was the serious harm threshold and there was the more than minor harm threshold. And one of the suggestions you gave me was, well, for your first submission, just say, New Zealand should adopt this threshold instead of that one, just to kind of effectively touch on both while not giving the other side too much airtime.
Yeah.
And Don, Josie, anything to add to that?
Well, I think Diana's really sort of covered all of that. The only thing I would say is that, you really want to not spend too much of your time and energy or your written submission space really to deal with counter arguments. Like Diana sort of said it, you set it, you put it in an although, you make it like a couple of sentences, like a couple of words, and then you just lead into your conclusion. But that really should be the extent in which you go to address a counter argument. There are many reasons for that. The first one, which is that in your written submissions, you are focused on making your case rather than your opponent's. And second of all, when you're in your written submissions, very often you don't really know what the other party is going to say. So for example, if you're the appellant and then you just sort of anticipate that the respondent's like argument and you deal with a chunk of your submissions deal with that, and then they don't raise it at all, then it just becomes like a complete waste. So what I have, my rule of thumb that I would suggest, I think, is to try to avoid dealing with counter arguments unless it's really obvious and you can deal with it quite quickly. You can generally save counter arguments for your oral submissions, and that's probably where it'll be most persuasive either way. So I think in the written submissions, really focus on making your argument and not about trying to counter your opponents.
Yeah, totally.
The only thing, yeah, can you guys hear me still, or is it bad? Right. I think I don't really have much to add. I guess that I would just say that's probably where mooting in practice differs, because in practice you would have already had a statement of claim and a statement of defense. You already kind of know what the other side is going to say, but it is harder with written subs in a mooting sense, because you just, you hand in your submissions, even though you might be the respondent at the same time as the editor. Obviously, they kind of give more time to those counter arguments when you get to your oral subs and you've had time to look at the other side's submission.
Yeah, totally. And I think just in the interest of time, let's talk about the really exciting part of mooting, which is oral submissions. And I think here is where the conversation just kind of pops off. So to kind of try and give it a bit more structure, we've split it into the questions into a few parts. The first part is about being an engaging advocate. The second part is responding effectively, and the third part is engaging with the bench, and the last part is international mooting. So on the first part about being an engaging oral advocate, the question I'd like to throw to everyone is, how do you strike a balance between, flexibility, moving between points, while covering all of your essential submissions?
I can kick it off. Diana's very good at this, so I'm sure she'll speak to it. She loves a bit of structure, but I think some of it comes down to style, how you might do it. I definitely think you need both. You do have to have good structure, and you can start off with structure and come back to your structure. It's kind of your little home base that you always have as a touchstone. But flexibility is obviously a really important thing, especially when you've got a lot of questions. But I think also with being an engaging advocate in general, you are going to have your own style, and it's really good to learn off other people and pick up on the things that you see that they do. That's really helpful, and make sure you get the basics right. But it's also okay to have your own style and to have your unique way of communicating. I think I'm probably a lot more informal than Diana is, I mean, she's also a lot better than me, but in general, we just have kind of different styles. And that's, you have to lean into also what you think is comfortable for you.
Actually, since you mentioned style, I did just get a question because everyone does have their different kind of style. Could you guys talk a bit more about what defines your personal style and perhaps how you arrived at, discovering a style that works for you and refining that so it makes you a better advocate?
Well, I think I just look at Diana Moot quite a bit and I just copy what she does. I mean, she's the OG mooting queen, but I mean, I think there wasn't really, in terms of style. So I first got introduced to mooting, I think, through Michael Greenup, and I think he had quite a distinctive style in terms of how he spoke. And so from how he did his moots, essentially, that was sort of my first way I started from, I suppose. And then as you sort of go through your mooting career, I think you watch different people moot and then you learn different things that, you pick up from different people. Like, for example, whenever I sort of moot, if it's a final or something, I'll be watching other people, and while I'm trying to think of how to respond to them, sometimes I'm like, oh my gosh, that was such a smart thing to say, and I write it down, or that was incredible technique, blah, blah, blah. So you kind of, once you sort of do that, you really build a base in terms of all the things on how you respond to certain things, I think. In terms of style in general, it's just this camera, which I have parts of Diana and other people inside. I would say a few things. So, and I just sort of remembered this was an introduction to, I think Lord Bingham. I think I just did this for something for my judge. But anyways, I just remember very clearly because they talked about 3 different kinds of style in terms of the 3 best advocates in the United Kingdom at the time in England. There was this advocate. He was silver-tongued. He gave the impression very eloquent. His only concern was trying to stop the court from making a terrible mistake in terms of what it would decide. And then there's another style where I think this person was very, very invested in his client's outcome, and so he really, stuck to his guts and always tried to push through his points, and was always persuaded of the merits of his client's case, and was Lord Bingham's own style when he was an advocate, and that was about in terms of positions, really honing them, supporting them with authority, and pushing them through very, very carefully. So I think there are a lot of very different styles. You will find your own specific style for yourself. Yeah, I really couldn't say much more in terms of my style. All I can say is that as you watch mooters, as you watch great speakers, you pick up different things, and all of these will essentially culminate in what you have in terms of your own style. And I think just to really trust yourself and not try to force yourself to speak in a way that's very artificial to yourself, because it's intended to be quite conversational. And you just don't want to come across stilted, artificial. Mooting is really, we tend to watch television and all that, and we see lawyers speaking in a certain way, but what it really is, I think, is just you having a personal conversation with the judge, and that's also, speak how you normally speak, and don't try to take on, try to force through some sort of appearance, or take on some character.
You definitely have your own style, because you wrote that mooting jargon book. And then I think what's happened is Sean actually told me that he kind of realizes when people have read that mooting jargon handbook and use it, because they sound a little bit like you. But so yeah, you definitely do have your own style.
I would say one thing as well is that potentially don't rely too much on that jargon sort of thing, because then everyone starts to say the same thing. It gets real weird, and then you sort of force your language into these artificial contraptions, and it just doesn't feel very organic. So that's helpful as a tool, but don't rely too much on it, I think.
It's why there's also a disclaimer at the top of the jargons document, I'm pretty sure, which is fit this to your natural, fit this to your own vocabulary and natural speech patterns. I think that's really important. Yeah. I want to really second what Josie and Don has said, especially the part about not forcing yourself to speak in a way that doesn't feel natural to you. So Josie said, I think I have a formal style. I think I'm also very structured. That's just because like that's kind of more or less the person I am. And also the structured part comes from the way I think. So like for me, I like having structure because it makes things clearer for me and it's easier to process. But that might not be your style, and that's perfectly fine. There are definitely various styles out there. Similar to Don, I developed my style from watching a lot of really good mooters, both domestically in our finals competitions, as well as internationally in Australian and international finals. And from there, I picked up the things that I thought they did well and that I really liked, and also some useful phrases to use, which I thought that I might consider adopting into my own mooting. So as a result of that, my style came forth. What I'll say here also is, for those of you thinking about experimenting around with your style, for me personally, I found trying to consciously vary up my tone and my pace really helpful, because one of the pieces of feedback I consistently got as a student was oftentimes, because of how formal I am, I would often sound quite monotonous, and it wasn't until I think the Viz or the Jessup where I really started to experiment around with that by making my voice more high-pitched at times or lower-pitched at times, varying the speed at which I was making submissions and taking pauses in between sentences, especially at the end of submissions before moving on to the next one, in order to make that make the first submission more significant, or to give it the weight that it deserved. So experimenting around with those things, I think, is really helpful, because it shows you what you are able to do with your voice. And I think knowing what the limits of that are is helpful, because then you can move within those limits. I remember one of my teammates, when we competed in the Viz Moot, he was often criticized by my coaches as also being quite monotonous. And so my coaches basically told him to be really hyperactive in the mood. And so he'd end up having these, what sounded to us, his teammates, exaggerated submissions, like just really high energy, really unlike, I guess, like the sort of person that he was. It was persuasive, although it sounded artificial to us as his team. But sometimes that is something that you might also just consider experimenting around with. So that's, I guess, what I'll say about style.
Cool, awesome. And I am just gonna jump in because my chat has been popping off, and like just quickly reading through everyone's questions. I think one repeating question that I keep getting is people want to know how you actually turn your written subs into an oral submission. Like, how do you kind of convert your argument into something that you can present orally in an effective way to the bench? So would you guys be able to share maybe some more specific advice, or like maybe how you yourself do that, go through that whole process?
Yeah, from memory, so it has been a while since I've done mooting. From memory, I think what I did was I use my written submissions as a basic framework / template for my oral submissions. So I had an oral submission script, if you will, where I basically bullet pointed the things that I wanted to talk about. I copied over the subheadings from my written submissions and the general point of each paragraph in my written submissions into my oral submissions script. And then from there, I would constantly ask myself, how would I talk about these points underneath each subsection in the most effective way? And so I would look at the points underneath each subsection and think to myself, okay, am I able to structure this into a series of steps? If I can, that's great, because then it's structured and I like structure. And then from there, I would think about and always have in the back of my mind the questions that the judges might ask me, particularly if a point was going to be controversial. So then within my script, I would bullet point the point that I would make. I'd bullet point the authority right down to the pinpoint. And I'd also bullet point optional points that I could get to in the event I was asked a question on them, or in the event that I was going to be ahead of time. So in short, it was a matter of taking the very basic points from my written submissions and turning them into an oral submissions bullet point sort of shopping list, but doing it in a strategic way. So I like, from memory, that's how I did
it. Do you write like a full-fledged script of like everything you say, or is that like bullet point kind of, you know, what you go off?
I write out my introduction. So I write out my theory of the case, my prayer for relief, and there's something, and my signposting. Yeah, my roadmap. And then afterwards, it's just a matter of bullet points. And I often find that the more I practice, so practicing oral submissions is also very, very important. The more I practice, the more I start to develop like a memory of the sort of phrases I'm using, the sort of words I'm using, so that in the end, I basically just about have a script, except it's in my head. So that's what I do. I find bullets are just a lot more flexible because you will be moved around, and bullet points allow you to do that more quickly because it saves you time from having to read like paragraphs in your script, right? The other thing I'll say here is one coach gave me some really good advice about how to write an oral script, and it was have one submission for one page, and have it in bullets, and also each sort of line should be in size 14 to 16 font, because in that way you're forced to just really put down the most relevant points, and you also have like a document that you can read from afar without having to squint at it.
Yeah, that's a really good tip actually. And on that point, I think I've also heard that some people only print on the top like 2/3 of the page, because when you put the page down on like your lecture, you don't have to like, you know, lower your head too much, and you can just like sort of see the script. So yeah, Don and Josie, do you guys subscribe to the bullet point way of life, or are you more of a write every word out kind of person?
I hate the idea of writing everything out. I think it can be, I think it's really good to have your intro memorized and written out, and just because you're nervous, you know, so it's good to have that kind of like safety net there to start off with. But I found that people that write out their oral subs in full, it's not good with flexibility. Because especially if you're speaking second as well, like you might have written up a script, and what's actually come out in the wash in terms of your the other party's oral submissions might be different, and then you feel really panicked because that isn't what your oral script says. I think what is important though, and which I actually have a horror story of, I lost us the semi-final in Jessup because I didn't have on my like script, there were a few real important facts that kind of supported the propositions I was trying to make, and I'd had a note of the important facts, but I hadn't put where the pinpoint is in the fact sheet, because we had really long fact sheets. And you think you've memorized them, but then obviously you get a bit nervous and you get a bit flustered, and so I think it's good to have not written out the full fact, but it might just be a jog in your memory, like this case and the pinpoint, or this fact and the pinpoint, or what paragraph it's in, so that you don't get nervous and freak out and forget it. I spent like about a minute of one of my things trying to find where it was and marking the chord around, and it was a bit of a fuck up. So
I think you're being far too harsh on yourself, Josie. But
I agree.
Yeah. Well, I think just thinking about what Diana and Josie have said, yes, I fully agree in terms of using in terms of using bullet points and then having your introduction sort of memorized or scripted out, essentially. In terms of So a couple of things. First, in terms of having bullet points, I know it can be quite scary. And so what I had done at one point was that I would have bullet points and I have a script, but then I'll get too scared and then I'll start writing the script, and then it just doesn't go down that well. What I would say is that you really have to just trust yourself in terms of being able to speak to the bullet points, and it can be quite a scary experience. I think just having like insanity, or like one point there and you're like, oh my gosh, what do I say? And then you actually don't really know what exactly you're gonna say. So that's where like practice and stuff can come in helpful. But you really should trust yourself, and honestly do trust yourself that you will be able to speak from the bullet points, even though it can be quite scary going in without a prepared script. But then you have a massive amount of advantages in terms of that flexibility, but also having the advantage of not sounding stilted, because when you read from a script, as opposed to if you're just speaking from your mind, it's very different. And once we are sort of trying to go for the conversational sort of style, speaking to the judges from a script would really not come across well. The next thing, in terms of what Diana said in terms of having bullet points and then having optional points and having critical points and all that, that's in the ideal world, I think, and I would describe it as the Herculean mooter, I think, because very rarely do we have like in excess of time really to prepare so extensively for the moots, especially for the law school ones. For the Jessup ones, we had the advantage of like must have been 3-4 months, I think, to prepare for that. And so like I had stuff like the facts memorized down like for every single paragraph, and I could recite. I remember I was reciting it out to Diana in the airplane, and it's just getting annoyed. But my point is that you're not really
I
going
must
to
have missed that practice, Don.
Yeah, she fell asleep. So yeah. Anyways, yeah, you probably won't have the advantage of preparing that extensively in a moot, and honestly, in practice, you'll be lucky if you get to practice that once, I think, honestly. So take all of that with a grain of salt. That's the ideal sort of situation if you have an excess of time, and honestly, in terms of preparation, that's really the best thing that you can do for a moot. But once again, if you lacking time, you have exams, you have assessments, then what the best we can do is just read through the cases very carefully, have a full understanding of them, have your bullet points, and then once you have sort of accumulated all that knowledge, like, you will be able to speak to them from whatever and that will be very persuasive for the judge, even if you haven't had the opportunity to sort of like practice for hours and hours on end. So trust yourself and have those bullet points.
Yeah, and I find it's easier to trust yourself when you've done the prep. So guys, mooting is a lot of work, and I'm sure anyone who has done any moot would tell you that the hours and hours you put in, I think, typically help boost your confidence when you're actually standing in front of the bench.
Can I just jump in?
I do agree. You go, Diana.
Sorry, Josie.
I'm gonna get roasted by Diana, but just go.
No, nothing like that. I just want to jump in on the point of prep because I wanted to say something about striking that balance between flexibility and moving on with your points. There is no shortcut to prep. Doing a lot of prep means you're also likely, I think, going to be able to have the confidence to move on from an answer to the next point in your submissions. So oftentimes what I find is useful is, to the extent that it is appropriate, tying the end of your answer to the next point or the next relevant thing in your written submissions that you want to make. And oftentimes that comes from really understanding what your hurdles or milestones are and transitioning in a way that's natural to get to that next point. And the only way you know how to do that is if you know your case inside out. So you've done all of the prep. There's also some phrases that you guys can use to make those transitions, which I'm sure you've read about in the mooting jargon document. Things like having submitted on this point, that leaves only this point for consideration, to which I will turn now, or that leads on nicely to this next point that I'm going to make, and other phrases like that. So that's what I'll say is also something that the best international mooters do really well, being able to simultaneously answer the judge's question well as moving on with the points in their submissions and striking a balance between that.
Yeah, and did you actually bring up, responding to questions and stuff and engaging with the bench, which are the next two areas of oral submissions I had questions for. Maybe it would be good if we just talk a bit more on how you would respond to the other side's arguments and like respond to questions and like engage with the bench throughout the moot. So, like I know we already talked about addressing the other side's arguments in the written subs, but in the oral submissions, would you have like a different strategy? And, would you adjust your presentation style, I suppose, to suit the temperature of a bench? Because sometimes you have a very engaging bench and sometimes you have a bench that's just very, very cold.
I think the one big thing about engagement with the bench or just questions from the bench is like, which Diana, I learned a lot from Diana in that respect, and the coaches, is like, you get asked a question, you don't have to spit out an answer straight away. Don't like pause awkwardly for like 30 seconds, or maybe you will, I don't know, but have a think about it and always think, okay, like this is the question, but what is the concern? Because I think a lot of the times a judge might just have a question and you might just say something. And yes, that question might be scripted in that they've asked every other moot before you, that same question. But it might be that there's a concern, or there's a policy consideration, or there's, they're getting at an issue. And it's not just about answering the question, it's about being like, yes, that speaks to this issue. So I'm going to talk, and that's how you can link on to not just answering the question, but also linking on to other points. I think Diana, she would do a lot, or we would learn, you say, yes, that really, in answer to your question, that raises these issues. These are also my written submissions. I'll talk about them now, so it's kind of about knowing what the question is getting at, not just what the question is, kind of says on its face.
Clarify with the judge as well, right? I've seen you do that, your honor. So as I understand it, your concern is with, etc., etc.
Yeah, for sure.
Yeah. Diana and Dawn, do you have any advice on how to, respond to the other side's arguments and like be more engaging with the bench?
On responsiveness, I think the same principles with written submissions apply for the appellant. So you might get to a point where your first submission is in direct contention with that of your learned friend, in which case make that clear. Your Honour, my first submission is that the statement was about Mrs. Smith, contrary to what my learned friend has submitted at 2.4 of their written submissions, or something like that. Make the opposition clear. I think I was at some previous Mooting Society event, I talked about how in a case where the judge has to decide between X and Y, remind the judge that is the choices that they have to choose from. And then once you've reminded them about that, talk about all the reasons they should support your side, because it's not just your side or any other one of these other random sort of solutions. It's X or Y. It's the appellant or the respondent. So constantly put in those dichotomies, I think, and remind them of those choices throughout your oral submissions. When you're the respondent, you can also do that. I think you're also able to say, to point to things like, as my learned friend submitted, like the statement wasn't about Mrs. Smith, contrary to what my learned friend has submitted. I think the exciting opportunity that the respondent in a moot gets, that the appellant doesn't, is the opportunity to respond to the arguments that the appellant has given live. And this is a scary thing to do because you sort of have to think a little bit on your feet here. But the reason I think it's exciting is because if you do it well, it demonstrates, or has the potential to demonstrate, rather excellent advocacy. Something that I used to really like doing was taking a phrase that the appellant counsel had said in their submissions and then putting that into my own submissions as the respondent. So I would say things like, Your Honour, my submission on this point is this, and this is unlike what my friend said when he said, and then I would quote them. I'd actually use their words in that sense. And there's multiple different ways that you can massage that into your speech. This is also why, again, having bullet points on your script. This is also why it's important to have bullet points, because then in the margins, you can actually write down the phrase that your opposing counsel has just said, and then make sure that you come back to that. And I'll advise blue pen as well, so that you don't, confuse it with actual like printed text.
But it is quite hard sometimes, I think, and I've noticed some of the mooters struggling with this in last year's John Hay competition, to rebut or like to address the other side's arguments in a respectful way that doesn't come across as like, too petty or confrontational. So if you have any advice on that, I think that would be quite helpful.
Don't feel the need to rebut to every single point. Certainly don't feel the need to rebut to points that the other side has clearly gotten wrong. I think as a mooter, there is as an officer of the court, there's definitely a need to be respectful here. And part of being respectful, I think, is also being charitable. My coaches used to tell me, take your opposition at their best. If this person if your learned friend is making an argument, but they haven't quite gotten the specifics of it right, but you think you understand what it is they're trying to say, take them at their best, give them the benefit of the doubt. And in that way, you, in response to that ideal argument, can become more persuasive when you respond to it. There are phrases and words you can use to be respectful when doing that. I think the point is simply responding to the main arguments, especially where they're in direct contention with you, and not pushing points that aren't worth the fight. We were talking earlier about hills to die on. Choose the hills that you want to really engage in war with, or smaller battles with. Just don't again, be a reasonable person. There's no need to respond to everything, just the points that you need to.
Yeah, and I think that's a great point, because I remember now in 2019's ICC competition in the international rounds, there was one team that clearly got their position wrong on the law, and they were making arguments. I think the entire room was kind of stumped after they made their arguments, and it was just very obvious they were wrong. And I think none of the teams in the room actually were trying to beat them while they were down. Everyone just moved on from that, because the judges know the law, so sometimes you're not necessarily the one that's needed to make that point. But yes, Don, I would also love to hear your thoughts on everything that we just said.
Well, I think I'm probably not the best example, because early on in my mooting career, I was quite disrespectful to my opponents, and to the extent they would get pretty pissed off at the other end, and I'll just be like, Your Honor, my learned counsel submission has no merit whatsoever or something, and they would just get so flustered. But that's just an example of what you shouldn't do. I think I really do echo everything that Diana has said. You should be taking them at their best, and then sort of working off those points. I think that sort of leads to a further duty that advocates have for the court, which is that you are trying to help the court come to the best possible conclusion in terms of the law. You have your client's arguments, of course, but ultimately your goal is trying to help the court make the best law possible, essentially, if that makes sense. And so what that means is that you will need to, address the best of your opponent's arguments. In terms of responding to your opponent's arguments, I agree with Diana as well. As an appellant, you would have to, you're generally restricted to responding to their written submissions, which is more limiting. And then as a respondent, once you've heard the appellant speak, you will have a lot more opportunity to run to exactly what their focal points are. And you, I think, should remain, you should take this as a caveat, because you still have to prove your point. But very often, as you are if you're going through your argument as a respondent, you will quickly become aware of where the focal points of argument are, and you can very easily take the judges to it. And once again, taking us back to what we said before, having those bullet points will allow you to traverse the uncontroversial points quite quickly, so that you can get to the meaty stuff. And this will, I think, I'm sort of preempting what Arya is going to say in terms of the judges later, but be very aware, I think, that when judges ask questions in terms of, let's say the other side, let's say you're the respondent, they ask questions of the appellant, you can't take what the judges say as like their position essentially, because they will be testing your opponent's case and then they will be testing your case. So you can't be like, oh, judge, you said this, so therefore, like, why are you asking me this now? That's not exactly how it works. Like, what they will do will be to test your case to the fullest extent possible, and we can sort of pick out some of the points that the judges have said in response to the other person's case. Ultimately, once again, you're still focused on building your case and your point. The only thing as a respondent is that you really are able to jump to those like meaty points as quickly as possible. I will put an additional caveat, I think, which is that in practice, I think that's what judges want the very most. Like, they're not really concerned with, they're not how do I put this? Judges are very concerned with like the controversial points, like and so they will take you to those and they will want to hear your submissions on them. In a moot, very often you will sort of be starting from scratch and building the entire case as opposed to just jumping to the sole points which you need to prove. So I apologize if that was quite confusing, and it really does depend. It's hard to sort of speak in terms of the abstract and how you sort of respond to your the other side's case and stuff. But the most important thing, I think, is that when you're sitting at the counsel desk listening to your opponent argue, you need to really pay very close attention to what they're saying and what their weaknesses are, and then what, like Diana said, you take the keywords that what they are from their speech, and then you can sort of refer to them in your own sort of speech and like respond directly to what they've said. So yeah, hope that made sense, although it might not have.
No, I think it does make perfect sense. And actually, I will say to some of our participants here tonight, I know some of you come from a debating background. And I think one thing that's very important is for previous debaters to realize that mooting is a lot less adversarial, and fundamentally your focus as counsel and agent of the court is to build your own case, and you're only peppering in like responses, and do not sacrifice your own case for the purpose of addressing the other side's issues. And look, I think this conversation can happily go on for another 2 hours or 2 days, and I will still happily be sitting here. But I do think the time has come for us to wrap up, because I'm very conscious it is almost 8 o'clock on a Wednesday night. So my speakers, can I ask each one of you to leave everyone with one piece of advice and to finish off the evening?
Did you want to go, Diana?
No, you go, Don, you go.
Okay. Well, I think the fundamental and most important part of mooting, I think, is to just really have fun. So like, don't take it too seriously. Just like go in and focus on having that conversation with the judge and like practicing your legal skills. Mooting, first and foremost, is intended to be something that you enjoy, like almost like a sport in law school, really. So you should come in with that as your focus, and not, in terms of winning a moot, getting something, your CV, etc. It really should be about the art of advocacy and argument, which you should be enjoying. And by enjoying it, that's the best way which you become a good advocate, simply because you enjoy it. And that will, allow you to put in effort and everything. So do it for fun. Don't do it for like the grades, for the CV, or for anything else.
I want to say something about international mooting, because that was one of the topics, but we're not going to have too much time to go into much detail about that. And my advice is, if you can do an international moot during your time at law school, absolutely do, because the benefits of it are incredible. To yourself, okay, how am I going to do an international moot? I remember when Don was doing the John Hague, and I was sort of like guest judging, or like coaching / judging him in his practices leading up to the semis and the finals. How at some point I just had like almost no feedback to give to him, and I'm in international moot, because they and the strength of submissions from law students all around the world. And that is just not exposure you're going to get just by staying in your own university. Advice there is, I hope the Mooting Society can assist with arranging coaches for some of our international moots. If you have the opportunity to do one, absolutely do it. Can't recommend them enough.
All right, Josie, what's your one piece of sage advice?
Oi. I'd say, and this is said all the time, but I think role of like mooting and advocacy in general. Just as a quick point on top of what Diana said, yes, international mooting, amazing, is so amazing, and I was so grateful to have the opportunity. But definitely put your hat in the ring, even if you're not a really experienced mooter. I actually hadn't really done much mooting at all before I did Jessup, and I was just encouraged by a friend to give it a go. And it was such a valuable experience, and like I feel very grateful for it. But I was an absolute rookie, so I think it's so cool if you're a like really enthusiastic mooter and you've been mooting like your whole of law school and you've done all this stuff, which is amazing and really, really cool. But even if you haven't and you're in your last year or your second to last year, it's never too late. I'm so grateful that I did moot in the piece, and I wish I'd done it a bit earlier, but I think like there's always time for it. So don't think you're like past the point of, no return.
We just turned into a Terminator at the end, I think.
Well, okay. First of all, on the topic of international mooting, we do assist in selecting the team members for most international moots that the University of Auckland participates in. We try our absolute best to organise coaches as well, and we often have outstanding coaches who are experts in their area and who have just outstanding, excellent track record in legal advocacy to help you improve, which is just such a valuable experience. So yes, keep an eye out. Sign up to the Mooting Society, follow us on socials. We advertise these opportunities whenever they arise, and we are so keen to get everyone more involved in mooting and legal advocacy. And just to summarize everyone's best tips, have fun, be the most reasonable person in the room, and do more international moots and put your hat in the ring. And on that note, thank you, Diana, Don, and Josie so much for sharing all of your experience and wisdom with us. Thank you everyone for joining us tonight, and I hope to see all of you in moots very, very soon.
Thank you. Thanks so much.
Thanks so much for having us, guys.
Thank you.